All right, everyone. Thank you for joining us on another Saltivation podcast. Today we are with David Kupiec and Natalie Martin, and we are going to talk about kind of all things Illinois. So, Dave, Natalie, thank you so much for being with us today on the Saltivation podcast.
No, thank you for having
Thank you for
us.
having us.
And so, if you all can duke it out, but if you all want to just give us a background on who you are, kind of what you do, where you are, and how you got there, that would be excellent for our listeners to get to know you before we dive in.
Great. Natalie, I can go first. After law school, I went to work for the Illinois Department of Revenue in Springfield as an attorney. And after working there for a few years, I went to work for Arthur Anderson. That's where we met Stacy. And then after Arthur Anderson, one of our clients was ComEd, who had just merged with Pico Energy to form Exelon. So went to work for Exelon. And after 6 years there, we started Kupiec and Martin in 2008. So we have a little bit of a state industry and CPA experience. Natalie could go into her background too, but very similar.
Very similar. After law school, I worked for the state of California. I was a criminal prosecutor. So I like to say that I hope I never use that background with any of my tax cases, but it does exist. I then went to Arthur Anderson. I went to Deloitte for a bit after Arthur Anderson, and then I joined David Exxon, and then we've had Kupiec and Martin since 2008 as well. So, like Dave said, we like to pride ourselves in having a little bit of a unique perspective, meaning that Dave's been at the state, I've been at the state. We've worked for an accounting firm, we've worked in house, and we've now worked at the law firm. So we've kind of had all the perspectives so that we find that a little bit unique and very helpful to most of our clients.
Yeah. And most of our clients are people we've worked with over the years in one of those areas. So it's kind of funny, guys, especially as you guys know in public accounting and in industry, people kind of move all over the place. I always tell people be nice to people because you never know when your paths are going to cross again. And they do
Right,
multiple times. Which is,
Right,
yeah.
right. Don't burn those
right,
bridges.
Yes.
right.
Yes.
Maybe at a happy hour cost conference in St. Louis. Who knows?
Maybe.
Yes. Um,
Yes, well, I love that, and congratulations on your all's kind of professional relationship and enduring and being partners for so long together. That's amazing, and something for those listeners who keep coming back. We talk a lot about relationships on this podcast, and as state tax professionals, you can't know everything everywhere, and so that kind of your relationship either between your clients or yourselves has just kind of continued on in the various components of where you're at. Love that and glad that we can celebrate that with you. So,
Thank you.
um,
yes.
as we dive in, we did a little bit of pre-homework this episode, and so we wanted to kind of talk through some things. Um, there is kind of a recent court decision related to Pepsi. Um, what is the issue in this case, and what did the court decide? And maybe even give us
Yeah.
a little bit of background about how Illinois and their court system's set up.
Yeah, and Pepsi is a perfect example. It's an income tax 80/20 case, and the Illinois Appellate Court just issued a decision last month, March 19th. But what's interesting about this one is Pepsi has been litigating this issue for a number of years. And there's various buckets. This started with an audit, obviously, of Pepsi, and the only issue that's being litigated is the 80/20 company issue. But what's interesting is the first audit was directly appealed to the Illinois Tax Tribunal. And for those of you who aren't familiar with the Tax Tribunal, it's been around a little over 10 years. Actually, Natalie and I were involved when it was started through the Illinois Bar Association and CPA societies. There was the perception that Illinois wasn't fair because the Administrative Hearing Division was kind of under the umbrella of the Department of Revenue, and circuit court can sometimes be a little tedious, and you have to a lot of times pay to play with the Monies Protest Act. So around 11 or 12 years ago, everybody got together and they formed the tax tribunal for matters that were over $15,000. So as long as you have at least $15,000 at issue, you could go before the tax tribunal. The good thing about it is it only costs $500 for the filing fee. It's a somewhat formal procedure. in that, you do have a protest to file. The protest applications are online, and you can see how everybody else has filed them. You do not have any privacy. Your name has to be published. You can redact some of the specific facts, but it gives you an option because you don't have to pay to go into the tax tribunal other than the $500 filing fee. And then if you lose at the tax tribunal, you could appeal to the Illinois Appellate Court and then the Illinois Supreme Court. You also still have the circuit court system as an option after your audit, but in that situation, you have to make the payment to the Monies Protest Act before you go to the court. So sometimes people don't want to do that, and especially if it's a larger dollar case. I think, to quote someone we all know from costs, Mr. Paul Franco, don't pay, don't pay, don't pay. It's harder to get the money back once you give it to the state. So what's nice about the tax tribunal, and Natalie and I have had success in it, is even if you don't win 100% of the issues, when you're negotiating, you're giving them money. So you're basically giving them something that so you do still have a little bit of the power in that process. Whereas if they have all the money, it's kind of shifts the power advantage a little bit.
I
But
think
to talk a little bit more.
also,
Go ahead.
sorry, I was going to say, I think
Go ahead.
also just the tax tribunal, it only deals with tax issues. And a lot of our problems at
Yes.
circuit court
Yes.
was that there wasn't necessarily a real expert at tax. So
Mm.
you're only dealing with judges that are dealing with tax matters. So there is kind of also that ability to maybe perhaps get a better decision with a little more reasoning to go to the appellate court if you so choose.
Yeah. And what we found out is beneficial in the tax tribunal is both judges are very experienced, both in litigation and in the tax area. And there is an underlying undertow, both by the judges and the way this system is set up to resolve the cases. What you'll see is I think you have less than 20 decisions over the last 10 years because a lot of the cases are either withdrawn or settled. And it actually saves our clients money too, because you don't have to go through a lot of the extensive formal discoveries that are involved in circuit court. There's an informal process where if you pull the case out from the judge that's hearing your case, you could have this wonderful mediation with the other judge in the state to kind of look at where your case is at. And what we find extremely advantageous about it is the judges are very open as to where they're deciding. We were just in a recent case in which the judge told the department, "I don't see your case here." So when you have the judge say that in the early on phase of the status hearings, I think that kind of gives you a little more power to resolve the case. And at the same time, if he says it to us, you have to present more evidence to support our position.
Yeah, and that being said, too, I think the Pepsi case also shows that even within Illinois, if you're going to circuit court, there's a little bit of venue shopping. Some people prefer Cook County, which is Chicago, and some people go to Sangamon County, which is Springfield, the capital. So, the court system in Illinois is intricate and kind of interesting. So Pepsi kind of shows that. Dave, do you want to just go into just a bit about
Yes.
what an 80/20 is, just in case there's a listener that isn't
Yeah.
familiar with Illinois?
Well, before
So,
we do that,
Okay.
I just want to get some clarity around kind of
yep.
seems like there could be a fork in the road, right? You could go circuit court or you could go tax tribunal, but not both.
Yep.
Correct.
Correct.
Okay. And so because of the tax tribunal being in place and with some of these tax cases, it sounds like that would be the more potentially advantageous road to go so that you are getting judges that know tax rules are able to opine better and hear those cases better is kind of what I'm hearing from you guys.
Correct, especially if you know that they've decided a specific issue in a specific way,
Sure.
and as Natalie alluded to, now if you know that they've decided an issue against another taxpayer, you probably wanna do what Natalie just suggested, venue shop and go to Springfield. Yeah,
Gotcha.
and that's
Yep.
actually
Okay.
But
what's
I
nice.
think the paying is the big
Yeah,
thing too. If you have
Sure.
a,
the paying,
if
yeah,
you have a notice of deficiency that's multiple millions of dollars,
Sure.
it makes it very easy to go to the
yeah,
tax tribunal for $500.
Yep.
yeah. It's kind of where we
Okay.
were with Pepsi. They basically had a multi-million-dollar assessment. For those of you who don't know, Illinois, for income tax purposes, is a unitary state, and you include everybody in the unitary group. But there is an exception for companies that have more than 80% of their property payroll outside the United States. So what Pepsi did here was they basically set up a specific entity. They put all their expatriates that were doing work under internal agreements overseas at different international offices, and this one entity kind of was under Frito-Lay's division. So they were basically excluding all the Frito-Lay income and receipts from the Illinois Unitary Group, which created a nice state tax benefit based on the court documents that it brought Pepsi's Illinois income tax down to zero. So you saw this huge shift, and in doing so, it pretty much, and I hate to say this, but you pretty much guarantee an audit. When you go from paying millions of dollars to zero, the state's going to kind of say, okay, what's going on here? And that is kind of alluded to in the auditor's comments. They said they specifically looked during the audit as to what changed in this huge shift of income, not only from this entity, but from other entities that had foreign relations into this one specific entity to make sure that entity made the 80/20 test. And that's what the auditors focused on. The taxpayer immediately went to the tax tribunal, where, as we said, they only had to pay the $500. They didn't have to pay the multiple millions of dollars. Uh, but unfortunately for Pepsi in this case, the judge who heard this case really looked at this issue and said, under the economic substance doctrine, this had no substance, and basically said that these people were not reporting to anyone internationally. They were reporting to people internationally, but they weren't reporting to anyone in the specific subsidiary. So there's no control there. If you looked at them as employees, they weren't really employees of this entity because they weren't hired by this entity. They kind of discounted the intercompany employment agreements, saying that yes, they said they were going to do something, but they really had no control over them. And they basically said no. I'll use their exact words. They likened it to a sham. And I think one of the quotes the judge says, "With you can't remove millions of dollars of tax with one quick stroke of the pen." So in doing this, Pepsi says, "Okay, um, that initial tax tribunal decision was on summary judgment. They then appealed the protests, or not the penalties and interest. And then I hate to say it, but the judge even basically, under the next order, basically said, you know what? You have to have reasonable cause here. You guys should have known what you're doing was wrong. You don't have any third party, support for this. You didn't have any CPA or law degrees, provide anything. So they denied the penalty relief. And that's something that Natalie and I are seeing more and more, is that the auditors are really trying to get aggressive of penalties. Historically, Illinois has been pretty good about that. You could get the penalties, waived during the audit sometimes by the field auditors. Now that I think cases like this are giving the department a little more, strength in their positions and saying, you know what, we're going to go after people for penalties. And hopefully the pendulum will speed back where they're going to be a little more reasonable. But by having the judge say that, we're not going to abate the penalties, that didn't help. So then Pepsi says, okay, next audit's up. We're going to try something different. We're going to go, like Natalie alluded to, we're going to go forum shop, and we're going to go to the circuit court in Sangamon County. Well, unfortunately, the circuit court just issued an opinion a couple months ago saying, you know what, we kind of agree with what the tax tribunal said. Nothing has really changed from the first audit. And so the circuit court decided against them. To my knowledge, they haven't appealed that case yet to the appellate court. And then the third audit, which is kind of upright, the last, what's interesting, the circuit court was actually the most recent year, so there's a circuit court opinion on that. There's also a middle period too, which is still in the tribunal. So that's kind of pending, and I think that's up for status in June. So in short, Pepsi has an appellate court decision affirming the tax tribunal, saying you're not an 80/20 company. You have to put the income in and pay the tax, and unfortunately, you don't get penalty abatement. Then you have a circuit court judge saying the same thing for the most recent years, which they can appeal. We haven't heard anything yet, and then you still have those middle years. What's interesting about this is the whole underlying premise here is the judge in almost each one of these cases has basically looked for external documents or external support to say, what did this entity do that supports this economic presence? And during the initial tax tribunal arguments, one of the former VPs of the taxpayer basically testified, what the substance was. But the judge wanted more documentary support and said, unless we could show documentary support to support this testimony, we're not going to give it the support it needs to get you to that 80/20 test. So it kind of shows the importance of having the documents, internal, external, and both judges, the appellate court and the Circuit Court and Tax Tribunal kind of made reference to external documents. So one common thing we're seeing now, not only in this case but other cases, is if you're taking a position that's not clear, you might want to have something from either your CPA firm or an accounting firm or a law firm just to kind of support that position, or a letter ruling. Get a letter ruling from the state to kind of give you some support because they're kind of saying that they want more than a testimony.
Yeah, and I think documentation is probably a big issue that we're seeing in Illinois. There's another case, the Lowe's case, which recently came out as well. And that really talks about documentation that you could have, that you have some kind of a burden to update. And you also have a burden to review documentation that the Department of Revenue is providing you as well. In the Lowe's case, that dealt with construction contractors, which we don't need to get into in too much detail, but the overall premise was that there was a bulletin issued by the Department of Revenue explaining what is and is not a construction contractor in pretty specific terms. There was perhaps a little wiggle room, but they had noticed that the issue was a gray area, and they were trying to provide explanation and some examples and what have you. In the Lowe's case, really what happened was Lowe's didn't necessarily follow that, and they didn't also have they had relied on a third party review before this bulletin came out. So the judge didn't particularly like that they didn't then have a outside third party review that document to opine if they would have changed their opinion. So I think the Lowe's case has a lot of levels to it. One of them is like, be careful with all of us living in same as last year, right? And relying on what happened last year because circumstances change, rulings change. You really have to keep up on documentation. And then secondly, even like Dave alluded to in the Pepsi case, keeping contemporaneous third party documentation about your positions is really important because it's not necessarily what your opinion was. Maybe there's a little bit of a burden now to go out and get someone to opine on what your position is. So, Dave and I are finding that a lot. Department of Revenue now has some more penalties too about record keeping requirements. We haven't necessarily seen them come into practice yet, but they have been talking, and don't want to say threatening, but it's a club that they have because, like you alluded to, also penalties are just getting really onerous and they're getting almost automatic now. So people are much more cognizant to them. So documentation's really important. Kind of a best practice too is when we talk about documentation, let's face it, we all live in 2025, but we're working in 2018, right? Or, way back.
Yep.
So what you have today is not necessarily what you're looking at. You're going backward in time. So systems change, people leave, paper files are gosh knows where. So, documentation is becoming more important, and it's somewhat harder now that we don't have the big old files that we used to have where you had your tax returns and your work papers and your comments and all of that. So we're really seeing documentation become more and more important, and as part of that, just your record keeping requirements with regards to your documentation.
I also
Mhm.
found the Lowe's case interesting from, like, it was how the case even came about and
Right.
how it was a competitive
Yes.
disadvantage
Yes.
to
Right.
another company. And so it's also kind of a little bit of a, "Hey, be careful out there," for,
Right.
even big companies, right? Because
Right.
Yeah.
if you've got smaller guys out there saying, "Hey, you guys aren't doing this right, and we know it,"
Right.
um,
Yeah.
And let's
that's
face
how
it,
that's how that came about.
I
Yeah.
probably didn't go to Lowe's to save sales tax, right?
Yeah.
We
Right.
tell our
Yeah.
clients, like, sales tax is you wanna get it right because most of the time it's not going to impact a transaction, but boy, is it gonna impact you if you didn't charge it, and 5 years later you get audited and you have to pay it out of your pocket. So let's
Yeah.
face it, I mean, Lowe's probably was taking a position, but would I go to buy a dishwasher from Lowe's because I knew that they weren't gonna charge me sales tax because they were considering themselves a construction contractor? I probably not.
No.
So
Mm-mm.
it was, once again, sales tax, just try to get it right because it's unlike income tax. You're not going to probably go back and try to recoup sales tax from all of the people that you should have charged it. And in Illinois, we probably shouldn't call it sales tax. We should call it retailer's occupation tax because it's really
Yes.
borne on you anyway, but you pass it through to your customer. So, yeah. And I also think the interesting thing about Lowe's too is Illinois is unique in the KETAM kind of Fair False Claims Act. They allow it to be for tax. A lot of states don't. So you're going to see these cases where it becomes, did you charge me the correct sales tax? Did you overcharge me? Did you undercharge me? And the competitive disadvantage. And boy, the penalties with regards to that are a whole new level, right?
Yeah.
So we also tell our clients it becomes important to get sales tax as right as you can and not
Yeah.
overcharge because it opens up a whole other world of litigation that most tax folks are not used to or don't want to delve into.
Yeah, Natalie, can you or Dave, feel free to jump in, kind of talk through that KETAM concept? Because I don't think we've actually really talked about it much on the podcast. It's
Oh,
come up as
okay.
just kind of identifiers of things to think about kind of for like from a sales tax perspective. But it does come up when, we might talk to a new client or it's like, well, can't I just charge like 7% across the board or something like that? And it's,
Right.
some are going to be over, some are going to be under. But from my perspective, it's a wash. But you can't do that. Not all states are going to have kind of a KETAM concept, but it sounds like maybe Illinois does, and maybe it's as like an outlier, maybe a little aggressive or lives in a different part of statute or whatever. So can we maybe segue a little bit and just talk about the
Yeah.
KETAM concept for a little bit?
Yeah, basically, it's Illinois laws on the sales tax side allow a third party to step in on behalf of the Department of Revenue and basically file a suit in court claiming that the right amount of tax wasn't collected. And usually, and a lot of these are when people charge tax or don't charge tax on delivery. And so you'll have one of our clients was subject to one of these suits, and I remember the first comment was, we don't mind that we're subject to the suit, but the fact that they bought the cheapest item on our website kind of really offends them. So it just because in order to get standing, you have to have purchased something. And one of the other cases, I think someone bought like a trampoline, Natalie, on one of the Walmart cases, and there's a bunch of different things. So some people will send out their administrative assistants or secretaries to the local mall or something, try to buy something online, and if the tax isn't calculated correctly, that gives them the basis to open the door to file a class action suit, not only on behalf of their purchase, but to bring in all these purchases. And what makes this really bad is it's a fine based on a per transaction basis. So you could really run up the numbers. It's not just the tax they're going after these fines, which could be very excessive. And most of these cases
Right.
end up
There's large damages, there's attorney's fees. So the
yeah,
play is not really the 10 cents of
tax.
overcharging the
No.
tax. It's
Yeah.
really all the other associated fees that are able to come in. And by way of background, I mean, our Department of Revenue in Illinois does not like these, right? They
Right.
really want to be arbiter of sales tax. They don't really want a third party plaintiff's firm to come in and be talking about the sales tax and how it should or should not be, you know, done.
Yep.
So the department doesn't even like this. Taxpayers don't like this. So it's kind of a unique thing. And as I said, they do allow it. A lot of states will carve out tax because they will
Yeah.
say there is a department that has specialized knowledge on this. I think a lot of states have these because perhaps the state attorney general doesn't have the expertise in a
That's what
particular
she said.
area, and there would be a plaintiff's firm that would have more expertise. In Illinois, the Department of Revenue has the expertise, but it's still allowed under our False Claims Act for these third parties to come
And once again, just on the sales tax side, the income tax side, the statutory support isn't there to allow it. And that was kind of going back to Natalie's point is with sales tax, if you do it correctly, it shouldn't cost you anything. You could pass on the tax to your customers and everything. But this is where it gets really tricky is if there's a gray area, kind of with allowed to in the Lowe's case, is if you do or don't tax it, and if you're overtaxing or undertaxing, you could be subject to one of these lawsuits. It's actually in some of these cases we're seeing settled that we're going to talk about on the marketplace side. It's almost like you don't want a decision against you that you don't owe the tax that you might have charged because now you might be subject to this other lawsuit outside of the department, and it kind of creates a very uncertain position on some of these tax cases.
Yeah,
But
and
you
then
know what?
let's face it. Oh, go ahead.
I was just going to say, go ahead. I'll come back. Go ahead.
I was just gonna say, let's face it, we all like do the best we can, but sales tax is so intricate and so hard, and there's going to be errors. That's why there are error rates apply, right?
Yeah.
Because no one is perfectly perfect on every transaction, and the laws are gray. So it's just a really tough place to be. We just tell our clients to try to be as good as you can and get as close as you can, but no one's 100% perfect.
Yeah. When we were at Masada last year, or the year before, the director was kind of complimenting her how nice it is for the gaming and industry because the taxes they received on those are real time taxes. So when someone places a bet or uses a machine, the state automatically gets the tax instantly. And he's like, wouldn't it be great if we could do sales tax like that? Instant, and every in the audience who was not a state employee just had this look of horror on their face. Because they're like, could you imagine doing tax real time for sales
It's
tax?
hard
It would
enough
just
to
be,
do it
yeah,
20 days after the
yeah.
close of the month,
Oh,
right?
yeah.
Yeah,
That would
yeah.
be
Yeah,
impossible
it's
a
like
lot of times. Real time would
like,
be, I mean,
uh,
a lot of the
yeah,
times too, I think the departments of revenue, they understand the law and they understand what clients do, but they don't understand the intricacies of what lives between the sale and the remittance and all of the difficulty and
yeah,
all of the systems and everything that happens in between and the millions and millions of transactions, right? No, I can't pull this particular transaction up and call someone, or I can't, the nuance is not that, oh, I can have some system look that up real time to determine the taxation, right? I mean, it's that there are millions going through every day and then they're all getting ferreted into a system and then they're trying to get into your system, Department of Revenue, to give the tax to you correctly. So it's a real disconnect in reality of how things happen.
Well, not
And
to
once again, we're looking at like 19 and 20. So what was happening then is different than even our system now. So it's hard
Right.
to transition between the two.
Well,
Right.
not to mention even just and, maybe this will be a way to kind of transition to sales tax and talk about marketplace tax, but even just from that, like, logistics concept, we're also government prepaying you on funds that we may not have received, right? We're gonna send you an
right.
invoice for
Mhm.
maybe $3 million for a large software license that may or may not be where the five-prong test is gonna be applicable,
Right.
right?
Right.
So, maybe it is, maybe it isn't, and but now, going from 6.25 to, we're going full rate everywhere, right, to up to 10, 11%, we're, writing you a giant check for potentially one transaction that we may or may not recoup or may or may not, you know, somewhere down the line. So,
And that's
Right.
an incredible point
get that.
because trying to get that money back, right? Once you pay it,
Yeah.
it's really hard
Right.
because now you have to almost argue a negative to say, we owe this or we, didn't know this. So,
But
Yeah.
um,
also kinda going back to that full rate, I don't know if you guys realize, but, we used to here in Colorado think that our sales tax return was, like, the worst. I think you guys win now.
I think we have
yeah,
one now because
Yeah.
not only, you know, the interesting thing too is Illinois, the Department of Revenue collects it all and then remits it to the various counties. So you have how many
Yes.
hundreds of counties and taxing jurisdictions. And the vendor is supposed to know all of those, know exactly what rate to charge and
Mhm.
where and to whom, and then give it to the Department of Revenue. And then the Department of Revenue is supposed their systems are supposed to be perfect with giving it out to the jurisdictions.
Mhm.
Jurisdictions get their money, they spend it, and then oops, we shouldn't have given that to you. Or oops, it should have gone somewhere else too. So it's not only like our logistics, it's from the sale all the way to where it eventually should have been owed and who spent it at that end. So it's just it encompasses so much, and it's so intricate that it's very hard to get it all correct all the
Well,
time.
and
Yeah.
doesn't Illinois report kind of when you report your gross sales, isn't that like inclusive of tax? And then you have to kind of deduct tax to get to your kind of modified, almost like modified gross receipts. And then it's like, do you have any other exemptions or
There's like 2 pages of
non-tax
deductions.
deductions?
Yeah, yeah,
And so
yeah,
Yeah,
it's like, I
you
mean,
know,
no matter what, in all of those jurisdictions, so if I sell something to Naperville, I've got DuPage County and I've got Naperville and I've got the state, I have to report all of those as gross and I have a deduction at each of those components that like, I can't file this return. I can't file this
yeah,
return. I can't.
yeah.
right.
Oh,
It's
And then
hard.
I'm supposed to
manually
know,
is impossible. It
Yeah,
is
they
so
don't even
hard.
allow it,
Time
but
consuming.
then now they have this drop down with like you're supposed to know
Yes.
all the jurisdictions and all
Yes.
rates, and great. I applaud you for providing guidance, but that's not that easy, right? It just
Oh, no.
isn't like what they think it is. And that's
It's not
a disconnect.
intuitive. Yeah,
Yeah,
it's not
yeah,
exactly.
intuitive.
So Dave, do
Well,
you want
yeah,
to talk a little bit about, since we're talking about sales
yeah.
tax,
yeah. I think,
what you
no, nice
sales
Let's
transition.
fully segue, yeah.
tax?
Yeah. Well, and I'll start off what Natalie and I had the honor and pleasure, and we really tried in 2019 and 2020. We helped the state and IRMA and another agency draft the new legislation for the 2020 and 2021 legislation, and we really tried to simplify it and really tried to make it fair. And but just to give you a little bit of background, and Stacy, your state kind of is a little bit order acceptance, and that's where we started in the 1930s. We started off with this order acceptance thing where you basically source to where a person accepted the order. And as you guys know, there's a lot of manipulation around because you could pretty much accept the order anywhere. And so then Hartney came around in the Illinois Supreme Court in 2013, where they said, well, no, order acceptance isn't really fair. You can't rent a hardware store in the middle of Mark, Illinois, and pay someone $20 a week to pick up the mail and save billions of dollars. So they basically said, the Illinois Supreme Court says we're going to occupation of selling, and we have these 5 primary tests and these 6 secondary tests. Which made it even more complicated because now it's just like one test. Now you have these 11 things that you might have to look to. Then Wayfair came along in 2018, gave us the $100,000 and the 200 items, which made it a lot more simpler. But in Illinois, there was still a huge political undertow that really wanted this order acceptance. And that's kind of alluded to, Natalie said, but for the fall claims case, we're very political in Illinois. And it doesn't take a lot to stop someone from doing something that's right. We really tried in 2020 to do what Colorado had done when they went to marketplace to make things a little more simpler. But the political pushback was just too great, and it didn't happen. So what we ended up was with the marketplace use tax provisions for 2020, and that was kind of viewed as a transition year. So for 2020, any people outside of Illinois who met the um, $100,000 gross sales and the 200 transactions would basically source using a use tax, provision to Illinois if you had no presence in Illinois. But then the next year, the level of playing field, as we kind of alluded to in this conversation, some of the neighborhoods were like, well, wait a minute, Amazon's selling over there. They're getting all the tax dollars. We're not getting anything, even though our people are the ones buying it. So they came up with this level in the playing field legislation, which basically put everybody in a quasi ROT type destination, certain exclusions. And now those exclusions is what kind of led to some of the litigation and some of the recent legislation. Um, if you were a remote seller, you went from paying use tax in 2020 to ROT destination in 2021 if you had no presence in Illinois. Now, if you're a remote seller and decided, hey, I'm going to create a little small office in, Hinsdale, Illinois, therefore I could still do use tax. Well, you could tell the people who are outside Illinois with no presence are basically saying, why are we going on destination, and why is someone who just rents an office in Illinois get to do use tax? So that led to some litigation. That was the pet medis. That's kind of the gist of it. Is basically saying you're unconstitutionally treating out-of-state taxpayers differently by themselves, and even if you own a little piece of property or lease something, that constitutionally doesn't, get you to where you want to be.